Hello, everyone. Good evening. I am Yael Brudner, immigration attorney, here coming to you live from Orange County, California. I hope everyone is having a great evening wherever you are. Thank you so much for joining us. Today, I am here to answer your immigration questions. I am live on Facebook, YouTube, and also on TikTok, streaming at the same time. So if you have any questions, feel free to write them down on the comments, and I will promise to try to get to them. If you're watching the replay of this, also feel free to write your questions in the comments, and we'll get to them um, as soon as we can. So, hi everyone, thank you for joining. Just a quick kind of disclaimer, this information that we are going to discuss today is general information. If you are interested in getting a personal consultation to discuss your case, our team is actually here. They're ready to take your calls. If you want to call in today to schedule your consultation with me, I would love to meet you. Okay. But today we have a lot of great questions. Thank you for sending in your questions. We have really good immigration questions for today that I can't wait to get to. Okay, awesome. So, like I said, if you have any questions, feel free to write them in the comments, and I promise to get to them as we go. Okay, guys, let's jump into the first question. Okay, so the question is, if I got my green card through marriage, how quickly can I get my citizenship? Great question. If you are married to a US citizen and you are a permanent resident, you can apply for your citizenship for naturalization after 3 years. Now, you have to be married to a US citizen and living with your US citizen spouse for the last 3 years. Okay, so applying for citizenship based on marriage is the quicker way to go. It's an exception. The general rule is that you can apply only after 5 years. Okay, I really encourage everyone to, if you're eligible for naturalization, now is the time to apply. We've been seeing super quick decisions in citizenship cases. Interviews have been scheduled in a month, which is honestly, I've never seen them scheduled so quick. So if you are eligible, it's a really good time to file right now. Okay. Thank you for that question. Let's jump to the next one. Okay. I'm married to a US citizen. He started the process for me, but now he's saying that he wants a divorce. What can I do? This question comes up more often than you will think. And thank you for sending me this question. And if you sent me this question, I really want you to call us and schedule a consultation with me so I can talk to you specifically about your case, because I know how stressful it could be if you're in the process of the green card petition and based on marriage, and now your husband, your spouse, does not want to continue the case for you. Most likely, many times, you might not be in any legal status anymore. So it's really scary to be in this situation, because if you don't have anyone to petition you, you don't have a way to stay here in the US. But I'm here to tell you that that is not true. If you are married to a US citizen and and he started a process for you and now he doesn't want to continue, there is a very good chance that you can continue your case without your spouse. Okay, so there is a way to do it. There's a way to do it through something called a VAWA green card petition, and this is a special benefit for people that are in relationships with US citizens or lawful permanent residents, and the relationship is not going well, and they are suffering in their relationship, and they maybe have been subject to domestic violence, to maybe to abuse emotionally, mentally, psychologically. It doesn't have to be physical. So I want you to know that if you are in a process, if you're married to a US citizen, if they do not want to continue the case, you might have options. So please call us. If you ask this question, please call us. And if anyone else is in this situation, reach out. We'd love to help you with it. Okay. Okay, let me check some questions here. Okay. Okay. Raylene is asking about your brother-in-law from Algeria with a criminal record. Okay. Anytime there's a criminal record, you really have to consult with an immigration attorney to evaluate if your criminal record or if your brother's criminal record could make him ineligible. Okay. So, criminal record is something that you need a professional to disclose. Okay. So 1 second. Let me see. Sorry, I did something on TikTok. I just pressed a button that I didn't mean to press. Sorry. It happened to you as well. Do you have a question? No. Okay. Sorry. I am talking about immigration matters. So I'm just going to turn this off right now. Okay. It's okay. Okay, guys, this is what happens when you go live, right? I don't know how to do it either. Let me see. Okay. Okay, guys, sorry. Some issues going on the TikTok live. Sorry about that. So, Raylene, if we are going back to your question, if you will qualify for a waiver, he might, depending on what the criminal matter is. So, for certain criminal matters, you can ask for forgiveness, you can ask for a waiver, but those are complicated. Okay, so definitely have him schedule a consultation with an attorney for a personalized consultation. Okay, let's see. Alexis is asking, I've seen online that applying for a green card through marriage while on a TN visa is not recommended. Well, it depends. There is an issue that goes to intent. Okay, if you are applying for a TN visa, which is a non-immigrant visa, meaning it's a visa that's a temporary one for employment reasons, then you can apply at the same time for an immigrant visa, for a K1, for example, fiance, or for a spousal visa, right? So it's not recommended to do it at the same time. But if someone is here on a TN visa and then gets married, then that is okay to do it. So it's about the timing. And wait, you gave us a little follow-up information. So you're saying that you're looking into the K1 if it's a longer process. Okay, so just to summarize that, TN and green and immigrant visa or green card application is possible, but timing is key. You have to time it so that it's not at the same time. What is better, fiance visa or marriage process, the marriage spousal visa way? We get this question a lot because a lot of our potential clients, a lot of our clients, people that come to us, they're debating, right? They're in a relationship with a U.S. citizen. They know that they're going to get married and they want to be together, but they don't know what the best way to go, right? If they're going to do fiance visa, spousal visa, if they're in the U.S., maybe they are eligible for something called adjustment of status. So really, if it's a very personal decision, because there's a lot of different considerations that go in there. But to your question, fiance visa is not quicker really than the spousal route. The fiance visa now is taking a very long time, and it's, in my opinion, more cumbersome and more expensive because once you get here on a K1, you only have a 90-day visa basically, right? So you have to still go through the process of adjustment of status. But Alexis, please reach out. Our number's here on the screen. It's 714-794-9366. And we can schedule you for a consultation and really evaluate the different options and what are the pros and cons of each of the options. Because honestly, for every couple, it's different. I mean, for every couple, they have different preferences and they select different avenues for different reasons. Okay. So we're here. If you want to call, you can call right now. You can text, and we'll get back to you right now. Okay. Perfect. Thank you everyone for joining and for your questions. If you're joining now, feel free to send me your questions in the comments, and I promise to get to them as soon as possible. Okay. Okay. There's a question about siblings petition. Farakanda is asking about a sibling petition that was filed in 2009, 2010, and you have never got a response back. So a U.S. citizen can petition for their siblings for a green card. The issue with a petition by a sibling is that the processing times are very, very long. Depending on the country that your family member is living in and is a citizen of, it could be from 10 years to 25 years. It's a very long wait. So if you filed in 2010, that's within the time. It's not yet time for your petition. What I would make sure that you received a receipt notice, that the case is processing. You should have received an approval notice on your case, because what happens is with these petitions is that immigration actually will approve the petition. Could take a year, 2, 3. They will approve your petition, and then your petition will just sit there at the National Visa Center until what's called the priority date is current, until there's a green card available. So I would encourage you to make sure that you are checking that your case is in process. You should have a receipt number, and you can check that it is in process and is pending with immigration. Okay. Okay, there's a question. My fiance is from Russia, and it's 1 year since she entered into the States. Does she need to apply for asylum, or can we get more and apply for a green card? Well, if you're, what status did she come in as? Almost a year. Did she come on a fiance visa or on a tourist visa? Brianne, if you can give me a little bit more information. Let's see. And are you guys already married? Okay, so give me some information. What status did she come in? She came in illegally from where? Basically, what status did she come in? If she came in with status, and if she came in illegally, where did she come in from? Okay, give me more information and I'll try to respond. Okay. Samantha on YouTube, thank you so much for joining. And she's asking, what's the best option to get married in the US or in my country where I live? What could be your suggestion? I have a tourist visa. Well, for the purposes of immigration, it doesn't matter what country you get married in. Really, what matters is where you will do the process. If you are interested in applying for a green card, then where would you do the process? You are eligible to do the process from your home country through a process called consular processing, or if you're here in the United States and you have entered as a tourist and you decide that you would like to apply to adjust your status, you might be eligible for that as well. But the country that you get married in doesn't really matter, as long as it's legal in the country that you're getting married at. Okay. But if you're thinking about it, you're trying to figure out what the best way to go, then I really recommend to schedule a consultation with me, because we can break down the different options and the pros and cons of each one, timeframes, costs, everything that you need to know. So if you want to call us, we really are standing by to take your calls today. So the number is here on the screen. If you can't see it, it's 714-794-9366, or send us a direct message and we'll get back to you. Okay. Brian is giving us some clarification. Thank you. She came from Mexican border. She has an I-94 and has a court date, but they postponed it and have not yet set a date, and it's going to be a year at the end of October. Okay. So if she has a court date, then she is currently in immigration proceedings, and she would have to go through the process with the immigration judge. Okay. If you get married, there is a higher standard to prove the validity of the marriage if you are in immigration court. And the reason is because, the concern of the validity of the marriage. Okay. For your case, if it's better to apply for asylum or to get married or to just get married and wait, it's a very individual, personalized question. If you are already thinking of getting married and you're a U.S. citizen, then most likely and generally speaking, marriage to a U.S. citizen, even if you're in proceedings, is easier to win than asylum. Asylum is very hard to win, and only, unfortunately, a very small percentage of people get asylum in this country. Okay. Mayan Erez. Shalom. Hello. Is asking on YouTube. I'm married since 2020, and I filed all the papers myself. And I already got my EAD card, but just found out that I've been married from 2009 that I wasn't aware was even filed. What does it mean for my petition? So Mayan, just to make sure I understand, you filed for a green card based on marriage, and you just realized that you were previously married in 2009. Is that the question? If you can just clarify for me. Generally speaking, if you were married before, you have to show that you are legally divorced. Okay? Because if you were not legally divorced, then the new marriage isn't valid. But send me some more details, and I would love to talk to you on a consultation so we can figure it out and see how to fix it. Okay, so our intake team is here on standby. You can call us, you can text, and schedule a consultation. Okay. So Mayan's saying that yes, you got married, but we decided it was a bad idea and decided not to file it. But apparently he did file for marriage. So I'm not sure what do you mean by filed? Yeah, I would definitely, because it's a very specific situation, Mayan. I would want to just talk. Let's just talk one-on-one, and I can see how it can help you and we can square it all out. Okay. Awesome. Jean is asking, when you're trying to separate, what would the process look like when your spouse has not yet received a green card? So are you asking, if you can clarify to me what you're asking, are you asking that what happens if you separate, if you're a U.S. citizen and you separate from your spouse before they get the green card? Is that the question? Or if that's the question, and I would like maybe a little bit more details would help, but if that's the question, okay. And are you the U.S. citizen? It'll help me guide a little bit more. Technically speaking, generally speaking, you do need the petitioner, okay, the U.S. citizen spouse, to continue with the petition, right? That's generally speaking. That was one of the first questions that came in, right? The general law says that you have to, through a marriage case, you have to have a petitioner that will sign an affidavit of support, and we'll do the petition for you. However, there are cases where the beneficiary, so the person that's applying, can apply even if the petitioner does not want to continue the relationship anymore and does not want to continue the marriage anymore. Okay, so as long as you guys are still married, the petition can still go. It's if you are divorced, then it cannot continue the regular route. The beneficiary, the foreign national, will have to switch, will have to go a different route to continue their case, which is possible for them. But if you're just separated, then there is a chance that the case can continue. If you are called for an interview, right? I have personally been to interviews where the couple were separated, but they were not divorced yet. They were not even living together, but they were still not 100% sure that they are ready for divorce, and the petitioner wanted to be there and wanted to continue the process. So their case was approved, because you don't have to, you're not divorced yet, you're still married, and relationships have ups and downs, and you don't have to prove that the relationship is perfect. It's just, you just have to show that the relationship is real. So that was a long and winded answer, but if you want some one-on-one advice about your personal situation and what would be the obligations of a petitioner, if you continue with the case, then please reach out to us, and I can advise you about that. Okay. Perfect. Mike is asking, can you reside in Canada while applying for your Form I-130? Yes, absolutely, Mike. There is a process called consular processing where you can do your family-based petition, because it's an I-130, it's a family-based petition, through Canada. And basically the way it would work is that the petition will be filed here in the United States by your petitioner, and once the petition is approved, the case will be sent to the US Embassy in Canada, and you will go to do your interview there. Okay, so you can definitely do the process of a family-based petition from Canada. Thank you guys all. Let me check here on TikTok to see if there's any questions here. Thank you so much for all of your questions today. If you have any more questions, feel free to write them in the comments and I will try to get to them. And if you want personalized one-on-one consultation, then feel free to reach out to me, to our team, and to schedule an appointment with me. I'd love to get to know you and talk to you and see how I can help you guys. A question on TikTok is, I've been waiting for over 6 years now for my I-130. Why? Processing times are so frustrating. Honestly, I hear you. It's really upsetting. If you're waiting for 6 years, you're most likely in a process, in a category which is a preference category, meaning your petitioner was not what's considered an immediate relative. So in the world of immigration petitions, there's two kinds. Okay, not all petitions are created equal. There's two kinds of petitions. There are immediate relative petitions. Those are the strongest petitions. Those are the ones that are the fastest. Those are the ones that forgive the most. They're the most forgiving kind of petitions. And to be an immediate relative, you have to either be a spouse of a U.S. citizen, a minor child of a U.S. citizen, meaning under 21 of a U.S. citizen, or a parent of a U.S. citizen. So notice no resident petition. So if you're a resident, if you have a green card and you're petitioning for someone, then that's not an immediate relative. Siblings petitions are not immediate relatives. U.S. citizen parents petitioning for adult children, not an immediate relative. So if you're not an immediate relative, you're considered a preference category, and then your green card is going to take a long time. Anywhere from 2 years to 25 years. And it depends on what category you are in and what country you're from. because with preference categories, the government decided that they can only give a certain amount of green cards per country per year. So there's a line, there's a wait. And my advice is to, even though these wait times are insane and they're crazy, my advice is to file a petition, even if you know that the wait time is 10 years or 15 years, because these priority dates, these wait times are subject to change. And part of what immigration was trying to pass in immigration reform is that for certain preference categories, we'll be able to wait in the United States the time. So, and this is not yet, but if there is ever immigration reform, you might be able to wait the time here in the United States. So I really recommend it, even though it's a long processing times to do it. Let's see. Joyce is asking, unmarried child under 21 of permanent resident. Yeah, that's F2A. Yeah, that's the category that it would be under, and that unfortunately is not current as well. Right now, it's been current for a long time, but there's a wait for that category. Okay. Perfect, guys. I'm looking at the questions. If you're joining me now, thank you so much for joining. I am answering immigration questions today. So if you have any questions, please feel free to write them in the comments. Let's see. And I promise to try to get to them. If you're watching the replay of this, then also feel free to still write your comments, okay? On TikTok, my mom applied for her brother in December of 2016 from Bangladesh. How much longer? Bangladesh is probably about 15 years wait. So, probably, there's still some more time to wait, unfortunately. If I'm hiring for remote paralegals or interns, feel free to send us a direct message. And we'd like to touch base with you. Okay, there's a question here on TikTok about, once my 601A gets approved, how long does it typically take to get an interview? So 601A is a waiver. It is a request for forgiveness that sometimes some certain situations you need to request. If your 601 gets approved, that's you're almost at the last step. The last step is really your interview and your consular interview, your immigrant visa interview. From Mexico, it's about a year. It could take up to a year to get that interview. Okay. Okay. Okay, Mike is asking another question. While waiting for the green card through marriage, can the person who is not the U.S. citizen file any type of form to work in the U.S.? Okay, so Mike, if you're here in the United States, okay, and you decide, I want to get married and I want to apply for my green card. Okay, if you're here in the United States and you're legally here, then you can apply for your green card in the United States through a process called adjustment of status. If you apply for adjustment of status, then you can apply for a work permit to wait for your case. You can only do that. You can only get a work permit while your green card case is pending in the US. So if you do the process in Canada or in your home country, you won't be able to get a work permit. Okay, so to answer your question, yes, you can get a work permit, but only if you do the process here in the US. So because it's a little confusing, the different ways to go about the green card through consular processing or in the United States, I recommend to schedule a consultation so that we can review the two different options and the pluses and the minuses of each one and what you can or can't do while you're waiting for the process. Okay, so our numbers here on the screen, it's 714-794-9366. You can call or text us, or our team is here accepting calls. Farkanda is asking, can I send you all the information papers so that you can take a look? You can book a consultation with me, and I am happy to review your documents. Okay, Okay, so a consultation, why am I always talking about the consultation? Because really at a consultation, that's your one-on-one time with an immigration attorney to review your case and to listen to all the facts and all the history of your specific situation and then tell you the options. Many times there are different options, right? You can do this way, you can do it that way, and there's a lot on the stake. So it's a really good idea to get information about each of the processes. Okay. Yeah, we do. Raylene is asking, we do phone consultations, we do Zoom consultations, and we do also in person if you're in our area. We're in Orange County, California. So yeah, whenever, however you want. Okay. Okay, Eddie, I married my wife in Nicaragua. I applied for a petition on March 2022, and I'm still waiting. Why? I know it's really long, but if you applied in March 2022, that means that your case should be coming soon. Do you know how to check your case status? There's a way you can go on the receipt notice that you received for your petition. There's a receipt number. You can go onto the USCIS website, put your receipt number, and check case processing times to see for your case how much more time you need to wait. But for the I-130, for the petition based on marriage, it can take about 15 months if you're applying from a different country. So it's pretty much on track for that time. It should be very soon. Raheem has applied for N400. You did fingerprints in March, and my case is not updating. Okay. March is only 5 months, so it's totally normal that it can take up to a year for a naturalization case. We've just been seeing very quick interviews in Los Angeles, Orange County, San Bernardino, those counties. We've been seeing quick ones, but still processing times, they still say about a year. Let's see. Okay, Eddie, you're asking if there's any way for her to come here and wait. Honestly, practically speaking, probably not. Probably not, unless she has a tourist visa. She can try to come in on a tourist visa, but if she doesn't, then she would need to apply for one, which won't be approved because they will be able to see that there is an immigrant case pending. But it should be very soon. It should be soon. That the petition is approved, and then you can go the next step. Okay. I have a work permit. Can I travel to Alaska or Hawaii? Okay, Alaska and Hawaii, they're in the United States. So you do not need to go through immigration. If you have a work permit and you have your ID, you should be definitely fine with that. Okay, the only thing you need to be worried about is leaving the country without a visa to return. Okay, perfect. Okay, I'm going to do a few more questions and before we end today. So if you have any, please feel free to write them here in the comments. And I'm just going to make sure I didn't miss anything. Okay. Okay, I have a question here. I met my boyfriend online and we've been together for 4 months. Can he apply for a fiance visa for me? Okay, so in order to apply to qualify for fiance visa, okay, you need to have met in person at least one time in the last 2 years. Okay, you need to be a U.S. citizen. You need to have a fiance that you met in person at least one time in the last 2 years. You need to both be free to marry, meaning you're not already married to someone else. And if you were married to someone else, then you have legally divorced. Okay, and that you have to show that your relationship is real and bona fide, what's called, and that you have an intent to get married in 90 days. So if you meet all those requirements, you can definitely apply for the fiance visa. It doesn't matter if you met online, that doesn't matter initially, right? That you initially met online, as long as you also have met in person. Okay, guys. I'm going to wrap it up for today. Thank you so much for everyone that joined today. I'm attorney Yael. I am here for you. I'm located in Orange County, California, but we do represent clients from all over the United States and around the globe, honestly, around the world. So if you have an immigration case, we'd love to talk to you and see if we can help you. And if you're interested in getting more information about immigration, videos, live events, updates, and all that fun stuff, like us on Facebook, follow us, and subscribe for more immigration stuff. So have a great day, everyone, and I'll see you very soon.